Hello, everyone, and welcome. My name is Michael Dittmer, and I would like to talk about rental protections and community resources that are available to residents within the city of Milpitas in light of the recent coronavirus crisis. Again, my name is Michael Dittmer. My role is that I'm a rent stabilization analyst at Project Sentinel. Project Sentinel is an agency within the Bay Area that provides housing-related services and community mediation resources to various cities and residents within the Bay Area. For the purposes of today's presentation, I would like to touch on a couple of different topics that will affect you if you are a resident within the city of Milpitas. However, do please note that many of these topics will impact you even if you don't live in the city of Milpitas and may be useful to you as such. First, I would like to talk about an eviction moratorium that impacts renters within Santa Clara County. Second, I would like to talk about local resources that are available both for those who live within Santa Clara County and those specifically for residents within the city of Milpitas. Third, I would like to talk about applicable state laws that impact both rent increases and eviction protections for tenants within the state of California. Okay, first, let's talk about the most immediate item, which is the eviction moratorium that was passed for Santa Clara County recently. The Santa Clara County eviction moratorium was passed on March 24th of 2020 and became effective immediately. The moratorium will end on May 31st of 2020. On the most basic level, the Santa Clara County eviction moratorium halts evictions during the coronavirus crisis. In order to be eligible for the eviction moratorium, there are a couple of criteria you need to meet. First, you need to be either a renter, so for example, you have a residential lease, or you are a small business with a commercial lease. Second, you also need to have suffered substantial loss of income or substantial out-of-pocket medical expenses associated with the coronavirus. Do note that the moratorium applies to all cities and all unincorporated areas within Santa Clara County. That includes the city of Milpitas. Now, there are a couple more points that I want to make about the moratorium. First, on rent payments. The moratorium does not waive rent. The tenant still owes rent, but they are protected from eviction during the time period that the moratorium is in effect and covers them. Tenants will receive up to until 120 days after the end of the emergency moratorium to pay past due rents. Additionally, for tenants who are covered by the moratorium, their landlord cannot charge them late fees during the eviction moratorium. Tenant protections and responsibilities. The ordinance can be used as a valid defense against eviction proceedings. So, for example, if you get served with an unlawful detainer from your landlord, the existence of the law itself can be used as a defense if it were to go to court. Second, there are potential penalties for landlords who retaliate against or who prevent their tenants from using or exercising the rights given in the moratorium. It's an important thing to keep in mind. Third, tenants may be asked to submit documentation to demonstrate eligibility to their landlord as needed. A situation where this might occur is that if an eviction were to go to court, it is at that point where the tenant might need to have that kind of documentation ready, and then it would be decided by the court system. Also, just as a pragmatic note, tenants might want to have that documentation available so that they can, be in contact with their landlord and open the lines of communication about the types of issues that are affecting them and how coronavirus has indeed impacted their ability to pay rent. As always, no self-help evictions are allowed. A self-help eviction refers to a situation in which a landlord helps themselves to evict the tenant, such as themselves changing the locks or moving the tenant's belongings out of the unit. If you are a landlord and you want to legally evict your tenants, you will need to go through the court process of eviction, and then law enforcement will then enforce that eviction order, but you should not be doing it yourself. That was true before the moratorium, it is true during the moratorium, and it will be true after the moratorium. Along those lines, constructive evictions are also not allowed. So for example, if a landlord has loud construction noises or shuts off essential facilities such as water or plumbing or electricity to try to compel the tenant to move out, that's also an example of what we would call a constructive eviction, and that is not allowed. If you have any questions about the eviction process, or you are a tenant and you need immediate help after receiving an unlawful detainer, then we would highly encourage you to reach out to the Law Foundation Intake Hotline, and I'm going to go ahead and leave that phone number below. Okay. I would now like to also point out a resource that is available to both landlords and tenants. I'm going to leave this link here. This is a page on the Santa Clara County website. For example, there's a lot of great useful form templates that are available on this site. And if you have any questions or you want to reference any more information about the eviction moratorium, I would highly encourage you to go to the link shown below. Okay. I would now like to touch on some local resources that are available both for residents within Santa Clara County and also residents within the city of Milpitas specifically. First is the Santa Clara County Financial Assistance Program. Now, I do want to note that this program, from what we've heard as of the time of this recording in April of 2020, has been heavily oversubscribed, which means that there might not be resources available right now, or you might get put on a wait list if you apply to the program. But I still want to put this information out there. If you're eligible for the program, it offers up to $4,000 a month to low-income families impacted financially by the COVID-19 crisis. If you would like to apply, you will apply through Sacred Heart, and I'm going to leave that contact information below. There is another program that is specifically available for residents who live within the city of Milpitas, and that is the Milpitas Pilot Rent Relief Program. For those who are eligible, it provides financial assistance to pay rent for low-income and other vulnerable populations within the city of Milpitas. Eligible groups include families with dependent children, senior citizens, disabled individuals, subsidized housing tenants such as Section 8, victims of domestic violence, and emancipated minors and youth. It provides up to $5,000 per year in assistance, and it can be used for multiple rent-related purposes, such as rent, security deposit, domestic violence relocation, and other applicable uses. If you would like to apply, the program is administered through a third-party organization, the Silicon Valley Independent Living Center, at the phone number below. I will go ahead and leave that up there for a couple more seconds in case you want to jot that down. Finally, if you have any questions or you would like to get in touch with any of the programs that I've illustrated for the city of Milpitas, I would highly encourage you to go to the City of Milpitas website. There is an abbreviated link over there that you can click on that will take you to the resources page. Again, if you have any questions, if you want to start applying, I would highly encourage you to go to that page. Okay, let's go ahead and move on to the third topic of this presentation, which are relevant state laws that impact renters and landlords within the state of California, and of course, as such, residents within the city of Milpitas. First, let's talk about general requirements under state law. First, landlords cannot serve rent increases during the lease term. This was applicable, of course, before the moratorium and will be applicable still in the current and also in the future. So what this means, for example, is that if a landlord and a tenant sign a 1-year lease agreement then of course the contract of that lease would govern the price of rent for that year of the lease. The landlord cannot change the terms of that during the lease period. I also want to touch on noticing requirements. If you as a landlord serve a rent increase that is below 10%, you do need to give 30 days written notice to that tenant at a bare minimum. If you serve a rent increase of more than 10%, you need to give 90 days written notice. Please note that is different than before. Before 2020, it was a 60-day notice, but it is now a 90-day notice if it is above 10%. So please keep that in mind. There is also a new law that was passed in fall of 2019 called the Tenant Protection Act, or the TPA. Now, just for reference, it is also called AB 1482, which is a reference to Assembly Bill 1482. So the terms Tenant Protection Act, TPA, and AB 1482 may be used interchangeably. It is a new state law that became effective as of January 1st of 2020. It establishes both a rent cap of 5% plus the increase in the cost of living or inflation, known as CPI for many tenants, and it provides what we call just cause eviction protections for many of these tenants as well. So let's go ahead and dive in about what the TPA does. First, I would like to talk about what types of buildings and tenants are covered by the rent cap. If you are a tenant in an apartment building, in a duplex, as long as it is not owner occupied, or if you live in a single family home that is owned by a corporation and or investor interest, then you may be covered by the rent cap. However, the unit or the building needs to be at least 15 years old. Now, there are some types of properties that are exempted from the state rent cap. Affordable housing, so this is a technical term. So for example, if you live in an official city designated BMR or below market rate unit, you may not be covered by the rent cap. If you live in a duplex that is owner occupied, and I will point out that the owner occupation of the duplex needs to be continuous from the start of the tenancy, then the duplex will not be covered by the rent cap. Single family homes or condominiums that are owned by an individual as opposed to a corporate or investor interest are also not covered. Lodgers, so a situation, for example, in which a tenant lives in the same home as their landlord and they share common facilities like kitchens and bathrooms. That is potentially a situation that's not covered by the rent cap. Hotels, if you are covered by a stricter local rent control law. So for example, if you live in a city like Berkeley or San Francisco, those cities have their own local rent control laws. And so for example, if you live in an older multifamily apartment building, you will probably be covered by the rent cap of the local ordinance, not the state law. As of the time of this recording on April 15th, 2020, Milpitas does not have a local rent cap or rent control law. And as such, any rent cap is going to be issued to you by the state law, the TPA, and not a local ordinance. So you should go exclusively by what goes on in the state law. Care facilities are also not covered by the rent cap, like say a hospital or a nursing home, college dormitories, and any housing that is newer than 15 years old is not covered. The rent cap itself is 5% plus the increase in the cost of living, or CPI, right, Consumer Price Index, for a given year. So at the current time of this recording, it would be around 8.3% if you are a tenant who lives in Santa Clara County. Now keep in mind that CPI, the Consumer Price Index, which is this economic index that we use for the purposes of the rent cap, new numbers are issued on a monthly or yearly basis. Just keep in mind that after April of 2020, there may be additional revisions of these numbers for the new year that may come out that may impact this number. But as of the time of this recording on April 15th, 2020, just go ahead and use the 8.3% number. A couple of other points about the rent cap. There is a hard cap at 10%, even if CPI is greater. So for example, in a given year, if CPI is 6%, your rent would not be 11%, it would be capped at 10%. Second, setting of new initial rents, also known as vacancy decontrol, is an exception. So vacancy decontrol refers to a situation, let's say, where all of the original tenants who initially signed onto a lease have moved out of the unit and a brand new tenant or group of tenants are moving into the unit. In that particular kind of case, even if you live in a unit that is covered by the state rent cap, vacancy decontrol would still apply and a landlord could set a new initial rent. The concept of vacancy decontrol and its corollary, vacancy decontrol, can be a little bit more complicated. If you have any specific questions about vacancy decontrol, I would highly encourage you to reach out to me at Project Sentinel, and I will leave my contact information at the end of this presentation. Now, there are a couple of other things to keep in mind about the law. For example, rent increases before January 1st, 2020. If your landlord provided you proper notice, you would have had to have paid an increased rate through December if you were served with a rent increase in 2019. However, there is a rent rollback provision. So the basic idea is that in anticipation of a new rent cap or rent control law, landlords might try to get ahead of the law by increasing rents ahead of time. And so the idea behind the rent rollback is to roll back rents to the point at which they were at before the law passed. In this particular case, the law provides a rollback provision whereby rent levels are reset to the amount that they were at as of March 15th of 2019, plus the allowable rent increase for that year, which would be 8.3%. Let me go ahead and touch on an example of the rent rollback to give you an idea of what it would look like. Let's say that you're in a tenant, you live in an otherwise eligible unit on a month-to-month lease, starting on February 1st of 2019 for $1,300 a month. On September 1st of 2019, the tenant receives a notice from their landlord that their rent would be increased by $125 a month, which would constitute a 9.6% increase. And let's say they get that increase in October. In that particular case, the tenant would have had to have paid the increased rent, so that total amount of $1,425 for October, November, and December of 2019. Starting on January 1st of 2020, however, that tenant's rent would automatically reset to $1,407.90. So that's the $1,300 base rent plus the 8.3% allowable amount of $107.90. Now that we touched on the rent cap, I also want to touch on eviction protections known as just cause through state law. The basic idea behind just cause is that it modifies the at-will relationship between landlords and tenants. It protects a tenant's basic right to live at the unit. It protects the tenants from being evicted. And when I say it protects tenants from being evicted, that also includes a non-renewal of a lease. It protects tenants from being evicted or not having their lease not renewed for either no reason or for reasons not recognized by law. If a landlord wants to evict a tenant, or if a landlord wants to not renew their lease anymore, they need to have a legally valid reason in order to do so, as identified by the TPA. The tenant generally maintains the right to live at the unit, provided that they pay rent and follow reasonable rules. And I'll get a little bit more right now into what kind of reasons a landlord can give for an eviction. First, let's talk about covered building types. Covered building types, similar to the rent cap, would include multifamily apartment buildings, duplexes that are not owner-occupied, and single-family homes with a corporate or investor ownership. Additionally, a tenant needs to have lived in the unit for at least 1 year in order to receive the just cause eviction protections. And the unit or building, as with the rent cap, needs to be at least 15 years old. Now, do keep in mind that if a new tenant is added to the lease or the apartment, then at least one tenant needs to have lived there for at least 2 years. So for example, if you and 3 other housemates sign on to a new lease, and then one tenant leaves 6 months into the lease and is replaced by a new tenant, then at least one tenant needs to have lived at the unit now for 2 years before the eviction protections will kick in. As with the rent cap, there are a number of exempted properties under state law. Affordable housing as specifically designated, housing that's newer than 15 years old, hotels, owner-occupied duplexes, and that again, that is if the owner was living in the duplex at the start of the tenancy and continues to live at that duplex throughout the tenancy. Single-family homes or condominiums owned by an individual, not a corporate or investor interest. Care facilities, hospitals, religious facilities, school dormitories, lodgers, so the situation where the tenant and the landlord lives in the same house, they share the same facilities. And a final word, any owner-occupied single-family property with no more than 2 bedrooms or units that are rented out. Now, I would like to touch on at-fault eviction reasons. So there's 2 types of reasons that a landlord can give for evicting a tenant. An at-fault reason, which is a reason that is reasonably within the tenant's control, something that is, if you will, their fault. And then a reason that is a no-fault eviction reason, something that is outside the control of the tenant, but by law, per the TPA, is still considered a valid reason to evict that tenant. At-fault eviction reasons include basic things, such as failing to pay rent, very substantial or material lease violations, being a nuisance as defined by California state law, subletting if it's prohibited by the lease and is otherwise not protected by your city, refusing lawful access of the unit to your landlord, and using the property for illegal purposes are examples of at-fault eviction reasons. There are a couple of other reasons. I will go ahead and leave this slide up for a couple more seconds so you can just take a look at some of the at-fault eviction reasons that are present. Okay, let me go ahead and talk also about no-fault eviction reasons. So again, these are reasons that are outside of the tenant's control, but could still be considered a valid reason for eviction under the TPA. First is what we call an owner move-in. So that is where the landlord or a family member of the landlord credibly wants to move into that unit. Second, a removal of the property from the rental market. This is a very specific thing under the Ellis Act. So if you have any questions about that, I would encourage you to look more into that specific law. Third, any city code enforcement actions or court order requiring a move out. So for example, let's say that there's a gas leak at the unit and there's a government order to vacate. That might be an example of a no-fault eviction under state law. And then the fourth reason is, obviously on a credible basis, a substantial rehabilitation of the apartment expected to last over 30 days and requiring that the tenant move out. If a no-fault eviction reason is used to evict a tenant who is protected by the TPA, that tenant is entitled to 1 month's rent reimbursement as a payout for that no-fault eviction. Now, do keep in mind that if you live in a city such as San Francisco or Berkeley, those cities may have their own citywide tenant buyout provisions for no-fault evictions. And so if you are a landlord, I would highly encourage you to look into the specifics of those laws, because those laws may provide a greater buyout amount than what is provided in state law. If you are a resident within the city of Milpitas, as of the recording of this presentation, we are not aware of any local buyout provisions, which means that if you are a tenant in the city of Milpitas that is protected by TPA and you receive a no-fault eviction, then it would be governed by state law, which is that 1 month's buyout. Now, these laws do have an expiration date. The Santa Clara County eviction moratorium expires on May 31st of 2020. Again, I want to emphasize this point that past due or back due rents are due 120 days after the end of the moratorium. So even though the moratorium officially ends on May 31st, if you are still trying to get caught up on rent, you still are protected from evictions if you haven't paid that back due rent. Additionally, the Tenant Protection Act, so that's state law that provides the rent cap and the just cause eviction protections, That will sunset in 10 years on January 1st of 2030. I want to go ahead and quickly summarize the things that I've discussed so far. Many California tenants are going to be protected by both the rent cap and the just cause eviction protections of the TPA/AB 1482. If you are a resident within the city of Milpitas, you are eligible to be covered by the TPA as long as you meet the requirements that were set out and previously discussed in this presentation. The moratorium applies to all eligible tenants in Santa Clara County, including residents in the city of Milpitas. That leads me to my next point, which is that the protections of the TPA and AB 1482 apply independently of the eviction moratorium and vice versa. For example, you may be a tenant that's covered by the TPA, but are not covered by the moratorium. You may also be a tenant that's protected by the moratorium, but you are not covered by the TPA. And additionally, you may be a tenant that is actually protected by both the TPA and the eviction moratorium. But I just want to point out that they do exist independently. And so you shouldn't just think that because you have coverage in one, you have coverage in the other, or alternatively think that because you don't have coverage in one, you can't have coverage with the other. Fourth, any Milpitas resident may apply for rent relief funds and any county resources subject to approval. I point this out. So like, let's say, for example, that you are covered by the eviction moratorium, but you want to get caught up on back due rents, you may still apply for the rent relief funds in order to get help with that. If you are not protected by the moratorium, then again, you may apply for those rent relief funds to help you out with rent during this time. Additionally, I do want to point out that additional guidance continues to come at the state and county level. This is often fast changing. So even though this recording is being recorded as of April 15th, 2020, I would highly encourage you to stay on top of the news and also follow city, county, local, and state websites to see what is going on. For example, the Judicial Council of California recently issued new guidance about eviction court proceedings going forward. So again, just make sure to keep tabs on that. I'm going to leave a couple of resources in case you want to go for help. For tenant-landlord issues, you can reach out to us at Project Sentinel. And if you are a tenant facing an eviction, you may reach out to a couple of different places, such as the Law Foundation of Silicon Valley, Bay Area Legal Aid, the Asian Law Alliance, and the Santa Clara County Court Self-Help Center. I will leave these resources up for a couple more seconds in case you want to write any of them down. Finally, I would like to leave additional contact information for a couple of colleagues that I work with that may also be helpful to you. If you have any questions about any Milpitas-related programs, if you're a resident with the city of Milpitas, have any questions about the rent relief program, have any questions about another program that the city offers, the rent review program, I would highly encourage you to reach out to Robert Musalam, who is a staff member at the city of Milpitas. I will leave his phone number and email over there. And then additionally, I would like to leave a couple of Project Sentinel related contacts. This is my contact for me, Michael Dittmer at Project Sentinel, and also another great colleague that I work with, Mark Thomasy. Even though that email says fremont@housing.org, Mark works with Fremont as a jurisdiction, but he also definitely works with the city of Milpitas as a jurisdiction. So if you have any questions about your situation, you're looking for any input, any referrals to resources, Mark or me is a perfectly acceptable resource to try to reach out to. As always, during the crisis, please make sure to stay healthy, to stay safe. And if you have any questions whatsoever, please definitely encourage you to reach out and contact us, and we will try to help you in any way that we can. Thank you and have a good day.